Okay, we're in Article 10, parties generally. I'm going to read the CPLR first and then go over 2 questions, because I feel like these questions are pretty common sense and you can kind of figure them out without, but I want to do the CPLR reading first. This is mainly dealing with 1001B, but I'm going to just read all of it just so you have the complete picture. So the title of 1001 is Necessary Joinder of Parties, Parties Who Should Be Joined. That is the title. Parties who should be joined. Persons who ought to be parties if complete relief is to be accorded between the persons who are parties to the action or who might be inequitably affected by a judgment in the action, shall be made plaintiffs or defendants. When a person who should join as a plaintiff refuses to do so, he may be made a defendant. Then we go on to B. When joinder excused. When a person who should be joined under subdivision A has not been made a party, and is subject to the jurisdiction of the court shall order him summoned. They want him to come in, okay? If jurisdiction over him can be obtained only by his consent or appearance, without his being made consent or appearance, the court, when justice requires, may allow the action to proceed without his being made a party. In determining whether to allow the action to proceed, the court shall consider. So basically, this is, again, when joinder is excused, like that person doesn't have to be a part of the case. And so what it's saying is that in determining whether to allow the action to proceed. So basically, that's telling me, allowing the action to proceed, that it could, if these things line up, the action could proceed even though this party is not going to be part of the case, right? Not going to be joined to the case. And here are the considerations for that. And I feel like these considerations basically make a lot of sense, because it's basically these considerations are saying that, what is the effect that's going to be had on the case? Like, is the judgment going to be, is an effective, are we going to be able to come to an effective judgment, and if this case is dismissed for whatever reason, is the plaintiff going to have some recourse, an effective remedy, right? So these are things I feel that are like common sense if you really think about it. Like, if that person joining the case, has a derogatory effect on the ability for the case to proceed in a justifiable way through justice, then, these exceptions make total sense. So let's read over them. So number 1, whether the plaintiff has another effective remedy in case the action is dismissed on account of the non-joinder. Okay, and then 2, the prejudice which may accrue from the non-joinder to the defendant or to the person not joined. Like, what's going to be the, what's the word I'm looking for? Like, what's going to happen negatively? What prejudice will be held against the defendant or the person that didn't join? Number 3, whether and by whom prejudice might have been avoided or may be in the future, or may in the future be avoided. So this is all about repercussions. If this person doesn't join, are there going to be certain prejudices that will happen, or future situations where there will be prejudice held because of this person not joining the case. The feasibility of a protective provision by order of the court or in the judgment. I don't quite understand that one, the feasibility of a prospective provision. or in the judgment. I don't totally get that one, so I'm gonna leave that for you. Put something in the comments if you want to give some feedback on that. Number 5, whether an effective judgment may be rendered in the absence of the person who is not joined. In other words, is the judgment going to be effective if that person's, testimony or whatever that person isn't part of the case? So I feel like these are very reasonable answers. Let's look at the questions now and see how that lines up in the questions. So this was for question 139. If a person who should be a plaintiff refuses to join an action, well, this was part A of 1001. He may be made a defendant if the court can exercise personal jurisdiction over him, right? So it's saying he may be, because remember in that part of the CPLR, there was a whole thing about, where is it? It talks about jurisdiction and whether they have jurisdiction. If the court doesn't have jurisdiction, it's like the person may have to give consent to participate. Like the judge can't order if he's not within the court's jurisdiction, right? When they summoned him. If jurisdiction over him can be obtained only by his consent or appearance, see? So there's that option there. That's why they used the language may. And that's important because sometimes if it's may or must, that can confuse you. So, so that's where it says, hold on. He may be made a defendant, here it is. He may be made a defendant if the court can exercise personal jurisdiction over him. Okay. So that's the answer to that question. And then select all correct answers. In determining whether to permit an action to proceed without the joinder of a necessary party, the court should consider, and though the considerations are the 5 that I just read out of the CPLR, these are the considerations that we just went over. And I feel like they make total sense. Like if you didn't know the correct answer, you could kind of figure it out because it kind of makes sense. So it's A and B. An action may not continue without joinder of all necessary parties. Right? An action may not, and we know that it may not continue without joinder of all parties. It may not. When jurisdiction cannot be obtained over a necessary party except by his consent or appearance, which we just read, the court, in the interest of judgment, may allow the action to proceed without joinder of the necessary party. So there it is. Those are the 2. Now this is very interesting. C, which is wrong, is when a person who should be a plaintiff refuses to join the action, he may be made a third-party plaintiff. It does not say that in here. It says he may be made a defendant, not a third-party plaintiff. And that's in Section A, right? Subdivision A. It says he may be made a defendant, but he doesn't say a third party. So that's tricky. They're trying to trick your ass with that one. And then D, the effect on the court calendar congestion of permitting the action to proceed. That just sounds ridiculous to me. A calendar congestion. I don't know. Maybe there's a case somewhere else in the CPLR where that's the case, but that sounds like a pretty bogus answer. So it's safe to say that A and B are correct. Let's see if the answer key gives anything extra. No, they don't. They just are basically saying it's right. All right, guys, so that is CPLR 1001, subdivision A and B. And there you have it.